All right. Good afternoon, everyone. Happy Tuesday. We're glad you are here with us today. So I am Allison Scobber, Consolidated Planning Group, and today we are happy to be partnering with the Law Office of Christina Lesher, and we're going to be talking about 5 important documents that you need to have, and she's going to kind of go through the details. From a housekeeping perspective, a couple of things that you need to know. Today's webinar is being recorded, so you are going to get an email either later today or tomorrow. You're going to get a copy of today's slides as well as a recording. So just for note-taking purposes, I just wanted to let you know that. Today we're going from 12 to 1, so if you're planning your lunch, we will be done by 1 o'clock. As it relates to the webinar today, you are in webinar mode, and what that means is that we cannot see you or hear you, but we do know you're there, and we welcome your questions. We ask that you put your questions today in the chat box. Myself and Mandy will be monitoring the chat box for questions, and we'll just kind of interrupt and ask Christina the questions as we go along, and we'll get to just as many of those questions as we can. So before we kind of take off and get started, I want to talk a little bit about some of confusion as it relates to my industry and Christina's industry when it comes to special needs planning. Consolidated Planning Group, we are a holistic special needs financial planning firm. So, we help people plan for their finances, for their retirement, and for planning for the long-term care or future for their loved one with special needs. We're able to do future care cost estimates for those families that say, I know we need to plan, but I don't know how much we need to fund a special needs trust. We're able to do things like that. But we're also nationally certified as Social Security advisors. So we're able to, we actually have a specialized software that tells us exactly when and how for parents to pull the trigger on their Social Security to maximize benefits for their entire household and their special needs child. So, but what happens is a lot of times, Christina, people are calling me and they're saying, hey, I need guardianship. I need a special needs trust. There's, certain things that they need, and that's not what we do. But we partner with firms like Christina Lesher to handle those legal documents. So I like to say that you guys are the paper. You guys are the legal documents, the documents that have to happen, and we're the money. So when it comes to special needs planning, you actually need both. Christina's firm doesn't do what we do, and we don't do what she does, but we partner beautifully together on both sides, so that way you have a well-rounded plan when it comes to the planning process. Christina, do you want to add to that a little bit?
Well, the only thing I would say is I build the buckets, and you put the asset in the bucket for your special needs child or your loved one. But yeah, lawyers typically don't do the financial part of it, which is such an important part, because I can draft a nice trust, but if there's nothing in it when the parent or guardian dies, it doesn't really serve its purpose.
For sure. And, the thing is, you mentioned the word buckets, and that's one of my favorite words, whether you call them baskets or buckets or whatever. But the thing is when it comes to special needs planning, as you know, having money in the right buckets really, really matters when it comes to long-term planning for your loved one who may be getting any state or federally funded programs that they might be involved in. So we do a lot of planning and we spend a lot of time of making sure that money is in the right buckets. And one more thing before I turn everything over to you, Christina, I think one thing that is important to note, and I just want to say when it comes to planning for special needs, our situation as parents with loved ones with special needs is specialized. You want to work with someone who is specialized and specifically nuanced in special needs. I really believe in my heart of hearts that this is not a DIY project because it is so highly specialized, and we do highly recommend that you work with a financial professional that has a background in special needs, not just in financial planning, and that you truly work with an attorney that is nuanced in special needs as well. And what we have seen over the years is a lot of mistakes where maybe it was maybe the attorney next door or your brother, the real estate attorney or whatever, right? that said that they would do some legal documents for you for free or for a discounted price or something like that. And what we see is that there's a lot of mistakes in there, and that ultimately what ends up happening is you pay a lower price for that, but you end up paying a professional that is nuanced and special needs to fix the documents so they're right. So I just wanted to, take a moment to talk about that. So Christina, we're excited that you're here with us. Mandy, you as well. And so you're going to talk to us about the top 5 special needs documents. So please take it away.
Okay, and Allison, you're going to do the slides for me. So let's.
Yes,
yeah.
sure.
Okay. So thanks everybody for joining, and thanks Allison for you and your team for having me back. This is one of my favorite topics to talk about with special needs families is what do we need when we're thinking about planning for our child? Every parent, everybody that's caring for somebody else, we all need to have some type of legal instrument or estate planning document so that we have it memorialized in writing where our assets go at our death and how we're taken care of during our incapacity or our disability or illness. So up on the slide there is just, I would look at it really as a checklist for documents. We have our will or revocable trust that says where our assets go when we die. The revocable trust has some added benefits if you're disabled. Third-party trust, that's money that you give to a loved one that's on Medicaid or some type of public benefit. And then we also have what we call a first-party trust. I call these oops trusts in my office, which is, oops, something has happened, that mistake has been made, money has gone to a person who's on Medicaid, and now they are no longer financially qualified. We'll talk about it here in just a little bit. And then documents for incapacity. Even if you're married, even if you've been married a long time, you still need a financial power of attorney for yourself or your spouse, and maybe for your child once he or she turns 18. Medical power of attorney, make medical decisions, HIPAA release, declaration of guardian. We've got some other documents that we're going to go over, but the most important bullet point, aside from maybe the will and financial power of attorney, are these beneficiary designations. Allison, you and I have talked a lot about how you and I dream about beneficiary designations at night. What this means, everybody, is that if you leave, let's say, a retirement account to your child who's on Medicaid, and the retirement account paperwork says at your death, it goes to your son, and your son's on MDCP or SSI Medicaid, even if you've put together a supplemental needs trust or a special needs trust, that IRA beneficiary designation will go directly to him and will cause a problem for financial eligibility for Medicaid. So in other words, beneficiary designations trump your will, trump your trust, and they are something that you really need to spend some time. We'll talk about it here in a little bit, but I want everyone to go, that's listening or watching from home, to go through and look at where their assets go at their death, their life insurance through work. We'll talk about it some more in just a little bit, but the beneficiary designation cannot be overemphasized. Allison, anything else you want to add to that comment?
Yeah, I would add pensions. I know that pensions are becoming a thing of the past for a lot of younger employees and things like that. But old pensions from old companies that you may have worked with, we have actually seen some pensions where you cannot designate a trust as the beneficiary. We've seen some of those. So check your deal with TRS if you're with TRS. And also just know that, leaving that monthly stipend that you might be getting to your special needs child outright is an issue. And I'll just wait because we're going to kind of keep it moving, but we'll talk a little bit more about it. But there's a lot of mistakes every single day that we see on those beneficiary designations.
All right, let's do the next slide. Okay, so when we think about how we're going to leave assets to our loved ones at our death, there's really two kinds of planning that are most considered by lawyers and clients, and that is, are we going to use a will or we're going to use a revocable trust or both? So here's what a will does. A will is a document that is effective when you die, and it says where your assets go at your death. And it only applies to probate assets. So when you die, the law separates the things that you own, things that pass through probate, things that bypass probate. A life insurance policy with a beneficiary designation on it, you're not going to have to go through probate. Whereas a house, unless some other type of legal instrument is implemented, is going to have to go through probate. Here's the thing. If you have a very simple estate, a will may just be just fine for you. Probate in Texas is not scary. In fact, if you live in Harris County, Allison, we don't even have to go to the courthouse anymore for hearings. We just do it by Zoom and, you know, dress really nice from the waist up, and then there you go. You're ready for your probate hearing. There is some time that takes for wills to go through the probate system, usually 3 to 6 months, but you can leave a supplemental needs trust in your will for your child or your spouse or your loved one, and you can make sure that your will has that trust in it, and that trust would protect your child financially from losing Medicaid eligibility. However, because of the time lag with probate, for most of my special needs families, I like a revocable trust, which allows you to appoint you and your spouse, or you and your partner, or whoever, as a trustee during your lifetime. And after your death or at your incapacity, you pick up or you select a backup person known as a successor trustee to handle the trust assets. Because this instrument is a non-probate asset, we don't have to wait to go through the probate process for that trust for that disabled or special needs loved one to be funded. One of the main concerns I see with parents are they know that kids are expensive, that their child is receiving financial assistance from them, and when they die, they want to make sure there is no lag period. There's different ways that you can avoid that depending on your situation, if you really feel that a will is best for you. But I like a revocable trust because I think it provides more peace of mind. It's easier to administer. However, a will can be just as effective. There's a couple of situations where you will definitely want a revocable trust, and that is if you have out-of-state property, especially, and I always joke, property that's located in California or Louisiana or Florida or New York State. If you have any kind of out-of-state property, you're going to want a revocable trust. And the other thing I like about a revocable trust is that if you want a corporate fiduciary or a bank to be in charge of your money at any point in time, those corporate fiduciaries really like a revocable trust. Just a quick note on corporate fiduciaries. I have a limited amount of people in my life that I trust with my money. Okay, and so what that means is, at my death and my husband's death, we've got maybe one person, and then after that, I have a corporate fiduciary appointed to administer the trust for my children. And I do that because I recognize that being in charge of someone else's money is, you have to have that right person. Otherwise, you can have people make mistakes, Medicaid benefits could be lost, and so forth. But a will and a revocable trust can do the same thing. With a revocable trust, we still have something called a pour over will, which is if we forgot to put something in our trust, then that will just, what it sounds like, it pours it over into the trust. You still have to go through probate. That's a whole lot simpler. And again, we have a bullet point on carefully reviewing those beneficiary designations. Allison's right on the pension on those beneficiary designations. It can cause income problems and loss of Medicaid eligibility. Many of those companies will not allow you to name a trust. The one exception to that is that the VA, if you have a pension through the VA, they are allowing Supplemental Needs Trust to be the receiver of those pensions. So that's kind of the good news. It's super cumbersome and difficult to do that, but the VA will allow that. So depending on your personal situation will depend on.
Uh-oh, she froze on us.
Can you see me?
Okay, now we can hear you. You froze on us for a second.
Sorry. Okay, sorry about that. So I think what I was going to saying is, even if you have a trust, there's certain assets we don't put in there for tax purposes. That would be an IRA. Are we ready for the next slide?
Okay, I just have a quick question for you. Two questions. The first thing is what we see is that a lot of families have either no will or a will that's very, very, very outdated. So can you provide a recommendation of how often a family should revisit their will and trust, or have it examined or updated?
Let me tell you what I would prefer. Let me tell you what best practice is, and then I'll tell you what is probably more practical for families. I would like to see people once a year in my office. I want to see people. I want to review the documents with you. I want to see if your assets have changed. I think it's a lot less stressful than having to do it when people usually come to see me. And that is what I call the Ds: the divorce, the disability, the death. So I would say maybe every 2 years. Best practice every year. And I would say,
Okay.
I would say it. I know someone say annual updates to the will can be expensive. I saw that comment. Here's the thing. For most attorneys, you just pay what the consultation fee is. Maybe you don't need a whole redo. You just want to review it. And if you don't review it with the lawyer, at least do it with yourself, where you look at the document and you see if you like the people that are still listed, if they're still available to act as your executor, as your power of attorney. So even if you're not going to a lawyer to pay it, you pick a date. I usually do my wedding anniversary, where in June, we pull out all of our documents. I get my Excel spreadsheet where my accounts are at, and we make sure that everybody is where we need it to be. And I check our beneficiary designations. So you don't have to go see a lawyer. I would prefer them to come see me, because I have control issues and I want to make sure everything's perfect, especially on those beneficiary designations.
For sure. My last question is that when it comes to corporate trustees, it's true that some families, it's the end of the line.
Yeah.
Maybe they don't have someone that they trust in their family that is financially savvy enough to manage a trust that might have millions of dollars in it. Okay. Do you have any recommendations of corporate trustees? And you and I both know that corporate trustees are okay if that's the route that you need to go. And we certainly don't want to leave, somebody as a trustee that doesn't have the, capability of fulfilling the job, or there's trust issues. Can you just talk about that really quick? Because we see this a lot.
Sure. So when you appoint a trustee, they need to have the 3 T's: time, talent, and trustworthy. If they don't have that, then don't put them as the trustee. So then we think about a corporate trustee. How do you pick? I don't usually select a specific corporate fiduciary, because who I like right now may not be who I like 5 years from now, 10 years from now. In the document, I will do something that's called a trust protector, which is somebody that has a good head on their shoulders, but maybe doesn't have the time or isn't good with math or something, but they for whatever reason, they can't be the trustee, but they're a good watchdog. Let them pick the corporate fiduciary at the time of need. That's what I will do frequently in my documents. So, but there's lots of companies here in town that you can work with. I can send you a list, Allison, but again, they'll change. So who I like right now may not be who I like 5 years from now.
I like the way that you put that wording in there, because that does give the person freedom of choice, because who might be on the A list today definitely might not be on the A list 5 years from now. So I do think that is true, and companies are always evolving. And then sometimes people are afraid of the fees. Whether you have, true, if you have a family member that doesn't expect to be paid, that's one thing, but most of the time there are going to be fees associated with trustee work. And honestly, I've been that before, and it's a lot of work. It is a lot of work, depending on the level of assets and properties and all the other things that are involved. So we've had people before that were concerned that the corporate trustees won't put in writing in stone of what the fees are going to be. But what if you die 50 years from now? They can't lock in the fees for 2022,
yeah,
right?
It's reasonable and customary and these companies are governed by different agencies on what they can and cannot charge. So I would see it's not like you're going to pick one that's going to be way more expensive than the other. The questions for the corporate trustees is, do you have experience administering supplemental needs trust? Are you comfortable with that? If the answer is no, we only have one, that's probably not going to be the right corporate fiduciary. But it's an option.
Sure.
I'm going to have to use one for me because we just don't have enough people that are given the numbers and checkbooks. And also, you don't want to put somebody in a position where they're going to be a family member that will be a trustee and then make a mistake and then cost the trust a lot of money. So there is some benefit to fees. Yeah. So why do we need supplemental needs trust? Most families know by now that Medicaid programs, even though there's over 109, have a limit on the amount of assets that beneficiary can have. And I put the bullet point about the Medicaid programs because people tend to glob all Medicaid programs into one big program. And it's not. It's really a whole bunch of separate Medicaid programs that do different things, have different income caps, different asset caps. Some have waiting lists, some don't have waiting lists. Some have they all have different medical or disability requirements. So that's really the first step is you need to know what your child is on or what you want your child to be on. And then you need to know at least what the asset rules are. Generally for Medicaid, the countable assets are going to have to be less than $2,000 that are owned in the name of the beneficiary. So if it's in the name of the trust, it's not counted as an asset for that $2,000 asset cap. So there's few things that are not countable, such as a homestead or personal items, a car, personal clothing. Another question I get at my office is, I really trust my daughter, so I'm going to leave her the money outright for her brother that is on Medicaid. Bad idea, because that daughter may get married and then get divorced, and then the money will be swept up in the divorce proceedings, or they may have some type of creditor issue themselves. So we want to make sure that we separate the money into a bucket, put people in charge that are going to do a great job. And then that way, if the person who's in charge dies, becomes disabled, gets sued, that money won't be swept in to those types of problems. So you don't want to give money to another family member to hold. I fix a lot of those kinds of problems too at my office, where a sister's given the money and then something bad happens. So you don't want to do that.
The truth is life happens in everybody's life. People get married, divorced, they move, they get sick, things happen, and then before you know it, then the money's gone. One thing I just wanted to mention on 109 Medicaid programs in the state of Texas, the website HHSC, the Health and Human Services website, and applying for Medicaid, it's kind of an electronic service, so you don't have to educate yourself on all 109 programs. Their website, when you apply based off of the information that you plug into the system, should tell you what programs that your loved one might be eligible for. So I just wanted to mention that out there, the Health and Human Services website. And furthermore, Medicaid that comes, so you've got SSI and Medicaid, and that Medicaid comes with SSI. These other programs are different. So that kind of just comes hand in hand with SSI, but a person, for whatever reason may still qualify for a Medicaid program, even if they didn't qualify for SSI. So just keep that in mind. Absolutely.
And there's a whole bunch of Medicaid programs that are not disability based, and there's a whole bunch of Medicaid programs that are disability based. So that's where that 109 comes from. But I think My Texas, Allison, you're going to know the website better than me. I think it's My Texas Benefits. You can plunk in your numbers, and I think it generates a list of programs. Okay. We've talked a lot about this third-party supplemental needs trust. One of the questions I get in my office is, we don't want a supplemental needs trust because we don't want to have to give the money back to the government when our child dies. So in this type of trust, which is called a third-party trust, what you do is you leave money not to the child, but to the trustee of the trust. You update that life insurance. You make sure you have life insurance. Have that asset go to the trust for the benefit of the child. If the child never has ownership of that life insurance proceed, then at the child's death, it goes to whomever you want it to go to. One of the things I look at when we're thinking about third-party trust is we try to identify which asset is the best to be funded. And I like life insurance to go into these third-party trusts because, and Alice and I were talking about this before, you as parents may need your retirement accounts to live on after you retire before you die. So maybe at your death, there's not as much money as you wanted to give to your child that is on Medicaid or has a disability. Life insurance is a really nice way to make sure that no matter what happens to those retirement accounts, you've got some type of funding to go into the trusts that the attorney created. And one of the things I look at is how much life insurance somebody has. Lots of my clients think they're plenty insured because they have life insurance through their office, which will tell you that if you leave that job or you become disabled, that goes away. So we look to people like Allison to help assess client needs and figure out how much life insurance do we need? How much, Allison, you're working with a friend of mine. And I think what you said to her was so great. Yes, get life insurance. And then that means that you've got money to spend on travel. So we've got the trust taken care of because we've got life insurance coming into the trust. And now we know that we can do other things in our retirement years, such as travel or go, do activities that we love. So please go see Allison. They can do some kind of assessment to figure out what your life insurance needs. And Allison, like what other things do you guys look at when you're figuring out how much life insurance to
well, we look at a couple of things because we do an overall financial plan because ultimately, so yes, we do this, future care cost estimates for families of how much do they need to fund the trust for their child, but we also do the overall financial plan because our families are the ones that are funding their own retirement for 25 to 35 years, and they're also funding the future care for their loved ones. So we're able to do the overall financial plan and then plug the special care plan into their overall financial plan to see where it comes out, dollars and cents, and what is necessary. But the other thing that we look at is income replacement. So, if you still have another 15 or 20 years or however many years you have left to work, and that is kind of pouring into your overall financial plan, if a person becomes disabled or passes away prematurely, then that can certainly erode their overall plan. So one thing that I want to mention as well, you hit the nail right on the head, group insurance at work. The first thing I want to say, I am a huge fan of group insurance at work. And the reason I am is it is you can buy large amounts of protection for cheap or free, right? Super cheap or free. But what I am a fan of is that is gravy, okay? We're not planning on this. It's cheap or free, so you should take it. You can't get it cheaper, or better anywhere else. So you should take the max that you can take through your employers for life insurance. But it's true. It quits when you quit, retire, get fired, or go on disability. And then sometimes even employers say, hey, this is portable. But what they don't tell you is that you're no longer part of the group and the premiums are so high, nobody in their right mind would port it because it's so expensive. So having it during your working years for income protection, I think is important. And then the last thing that I wanted to mention is right now, as it stands, life insurance passes tax-free to heirs. Okay, so a lot of families use that as estate planning from a smart, smart financial move from a tax move, because life insurance passes tax-free to heirs. And this is including affluent people that have a lot of assets. They're not worried about running out of money, in retirement or funding their future care. So those are just a couple of places where it comes into play.
And I have life insurance. I have a nephew who has a disability, and I know as long as I'm alive and hopefully not disabled, I'll be able to help him out. And then I like the fact that if something happens, I've got life insurance that's earmarked just for him. That's aside from what my children will receive. So I know if something happens to me, my sister has money in a trust that's set up for her son to pay for all the things that I want him to have. So I
think it's important. And it's important to do it while you're still healthy enough and you can still qualify for insurance. You can lock your age in at the time that you buy it. There's a lot of things that way. But in summary, because you were talking about the third party supplemental needs trust, and you and I, we eat, sleep, and breathe all this stuff, but not everybody does. It's a lot to take in when we're talking about the 5 documents. So in short, the third party special needs trust, supplemental needs trust, or special needs trust, this is where you leave money to your special needs trust here for the benefit of said child. There is no Medicaid payback on the third party supplemental needs trust, because a lot of times there's confusion. So we're getting ready to move forward to the first party. But I just want to say that the third party is what everybody needs to have. This is the important one, and how we don't end up owing back to Medicaid. So let's talk about the first party supplemental needs trust that does have a Medicaid payback.
Okay, so this is the oops trust. Oops, something has happened. So a common situation in my office is grandma has left your child $5,000 in a CD and has named this kiddo in their name. So, they didn't name a trust, didn't name their estate. It's your child's name as the beneficiary. It trumps the will. So your child has 5,000, and you're thinking, this is amazing. Well, guess what? Medicaid has a $2,000 asset cap. Now, lots of times I'll tell the families, depending on the amount that the child receives, maybe we do things like spend it on a vacation or buy exempt assets, or get maybe dental work done that we've been putting off. Sometimes the families are like, no, we're not quite sure what we want to do, but we got to put it somewhere. So this first party supplemental needs trust is a way for us to put money that is in that Medicaid beneficiary's name, so it does not count for Medicaid eligibility financial requirements of having 2,000 or less. The person called the grantor has to be a parent, grandparent, guardian, or court order. It can be the child. It has to be written for the sole benefit of the child. The money comes out has to be for the sole benefit. We can have a whole 2-hour conversation on what sole benefit means, but basically it means that the child is the only one that gets the money or the expenses or any kind of distributions made for them. So you can't pay your own mortgage because it has to be something specific for that child. The money has to go in there before their 65th birthday. And this is the big downside, is that the money at the child's end of their lifetime has to go back to pay Medicaid, but it's only for this trust. It's not for the third party trust. Okay. There's some other things that we can do in addition to purchasing exempt assets. There's these ABLE accounts. I know that you guys have a great webinar on the ABLE accounts that I'm going to refer everybody to go take a look at the Consolidated's YouTube page. But the first party trust, it's the oops. Something has happened. Your kiddo has received money. Now there's more than $2,000 and you've got to do something with it. Maybe the ABLE account doesn't fit your needs and you don't want to spend everything all at one time. It's a way for us, as long as the child's under age 65, to set up a trust, preserve the assets, but there is a payback to the state of Texas or states where they've received this Medicaid benefit, but it's only for the first party trust.
So let's talk about this for a second. So on the first party supplemental needs trust, the oops trust, grandma and grandpa have left money. We see this all the time. In this example, this has happened. They've left the money. People ask us, can we just like not take the money? And the answer is no, because it was left to that said child. And when we just go ahead and contact you and you set up a first party special needs trust, do we need a court order from a judge to direct that money that was left incorrectly to the trust, or what do we need to do in that regard?
So if the child is not under guardianship, there's no court order required. If they're under guardianship, you have to go through the guardianship process. You have to ask the court. If the child's not under guardianship, you don't. But you always have to notify both Medicaid and Social Security of the existence of these trusts.
Okay, perfect. All right. And so the only other thing that I wanted to mention here that I think is important, and we really share this with all of the families that we work with, it is important. There's like fewer than like 150 advisors that do what I do that focus on special needs in the U.S. And to put that in context to you, there's 250,000 financial advisors in the U.S. and fewer than 150 that actually are nuanced in special needs. We really believe that it's important to have intentional conversations with your parents or grandparents or any family members that might be leaving money, because the probability of their financial advisor having any background in special needs is very small.
Yes.
And sometimes these conversations can be tough because we have family members that keep their cards close to the chest. They don't want to talk about money. They're not talking, and you certainly don't want to assume or say something rude. But one of the things that we've suggested is you just say, hey, listen, we've been working on our overall financial plan and planning for little Johnny, and we've learned that there's a lot of things that we can do that would accidentally, basically mess up his eligibility for, state and federal programs. And what we learned is the right way to leave money for the benefit of Johnny in the future, and that's through the Supplemental Needs Trust, the third-party Supplemental Needs Trust. And here's how we go about doing it. We're not assuming anything. We're not asking anything, but we just wanted to let you know because we learned that most advisors don't know about this. And, should you ever want to, this is the right way to go about doing it. And I know a lot of law firms even have a letter that they'll give you that you can share with family members on that. But having those intentional conversations can avoid the oops trust.
Absolutely.
Because your parents don't want to mess it up. They don't want to. Their advisor just doesn't know.
And I think too, families want to do something. They're just not quite sure what to do. Can we go, there was a question in the chat box. Can we go back to the third party trust just really quick? So
yes.
One of the questions was, what's the difference between a third party trust and just say like a regular trust that you would set up for a child, which I think is such a great question. The third party trust never lets that Medicaid beneficiary be their own trustee and has other language which limits their control or eliminates their control over the trust principal. A lot of trusts that we set up for grandkids or children will say they can be their own trustee at age 25, or they can have, some type of lifetime ability to redirect where the trust assets go, called the power of appointment. We have to strip all those powers out so that the beneficiary has absolutely no control over that trust. That's some of the main differences between a trust that you would set up for a child without a disability versus a child with a disability. Okay, so yeah, let's go to incapacity. Just wanted to take a quick.
We actually have one more question. Somebody says that they created a trust in 2002 for their daughter, and this is where birthday money and grad money has gone. Is this a first party trust?
I don't know.
that's a hard question.
I'm going to say it depends on the document. So I would go back and look at the document. Did the money go to her directly and then go into the trust, or did it go from the grandparent directly to the trust?
And one little, and that's the thing is, because we see documents that are incorrect all the time, and yours may not be. But one of the key things, sometimes they'll call it a first party trust, but in the example of a first party trust, sometimes we see it called the self-settled. Self-settled special needs trust. So you could look for wording on that. And of course, that you can get your document reviewed, by an attorney as well. And someone else asked, this is a great question because they are kind of synonymous, but is a supplemental trust the same as a special needs trust?
In Texas, they are. We just use these different terms because lawyers like to confuse people. I'm just kidding. I don't like to confuse people. I think in other states, it makes a difference, but not in Texas. Okay, so let's talk about incapacity. We talked about death. We talked about beneficiary designations. We talked about where things go at your death. Now we're going to talk about incapacity for you and then maybe your child. So one of the things we always want to reiterate and make sure we have is if you're married, you each have a financial power of attorney for the spouse. A lot of people think, oh, I'm married, I don't need one, or I have a benefit, my spouse is a beneficiary on my IRA, therefore he or she has access to that account during my lifetime. That's not true. You absolutely have to have a financial power of attorney in order for your spouse to be able to manage during your lifetime, okay? If you have a financial power of attorney already, great. This is what I want you to do is take every place where you have an IRA or life insurance, take that financial power of attorney, send it to the financial institution for their pre-approval. Sometimes banks are super difficult to work with. So even though we draft a financial power of attorney that's effective immediately, which I recommend, not effective at your incapacity. So I don't like springing financial powers of attorney because those are harder to use. I like powers of attorney that are effective immediately and then sent to each bank so that at the time of need, which is a crisis typically, their legal department has already pre-approved that power of attorney. Medical power of attorney, effective at incapacity, selects who's going to make medical decisions. A HIPAA release, I usually appoint this as a group of people who have access to your medical. So I'm just going to take a quick stop here and let's talk about these powers of attorney that for your children. So Alice and I, it seems like every time we get together, we talk about guardianship, Allison. We talk about this difficult and sometimes muddy decision of when a child turns 18, what do you do? Now, I prefer, and this Texas Estate Code requires what we call the least restrictive alternative. So if that individual can understand what a financial power of attorney does, it appoints someone to handle your finances, and what a medical power of attorney does, we will have a conversation with a parent about these documents. So we'll go through them, but I want you to think about in the context of not just for you, but also for your child. We have a directive to physicians. That's called sometimes a end of life document or a living will that says what you want to have done if you're in a terminal or irreversible condition. And then we also have a DNR, which is a do not resuscitate. A quick difference between those. I have a directive to physicians because if I'm sick and I'm incapacitated and there's nothing they can do, I want to be allowed to die as gently as possible. I do not have a do not resuscitate because I feel like I'm not getting younger, but I still like I'm still healthy enough that maybe if I had CPR, I'd be okay. Appointment of guardian for your child and yourself. The appointment of a child is a big topic. I think like the trustee, you need to think about who is going to be able and willing. And if you are the guardian of your adult child, you still need this. One of the things I want everyone to know, Allison, is that just because you appoint somebody in your estate planning documents as your child's guardian, that doesn't mean that they are automatically the guardian. They still have to be vetted and go through that guardian process. So this past week, I've had a bunch of guardianship hearings, and I told the clients, we're doing your will and your appointment for guardian, but if you die and your mom becomes your child's guardian, she's still going to have to go through that background check, get her fingerprints, and go through all of that, even though you've done the document. Okay. For minor child, we have an appointment of health care. I've got 2 rowdy teenagers, and I've got my mom and my in-laws listed. So if my husband and I are out, and no one can get in touch with us, they can consent to emergency medical care. And you may want to think about an appointment for a disposition of remains. That's who does your funeral, and medical study for body donation. All these documents, what they're meant to do is if you've passed away or you've become incapacitated, it provides clarity for you, for your family, on who's going to be making your decisions. And then think also about that for your adult child.
I just want to, two things I want to add here is think about this. We're always thinking about our kids with disabilities, right? But think about this for your other children that are going away, to A&M or UT or any of the other schools that maybe they're out of state, in state, it doesn't matter. When they turn 18 and they're going to college, you want to think about definitely the medical side of the house. We've seen things. There was a fire at Texas State where kids were hauled off to the hospital. We've seen in the last several years, we've seen kids have otherwise healthy college kids have mental health breakdowns where they were hauled out to a facility. They won't even tell you where they took your kid. Needle in the haystack of kind of where it is and what city they're in. So it's real important to have this. And then the second point I want to make here is this is another place to have truly intentional conversations with your parents or grandparents, any aging family members that you have in your life that maybe they haven't looked at this, in a long time. I think it's important to revisit this and make sure when everybody's of sound mind and body that they can talk about this and what their wishes are and what they want. So that way the things are in place as they should be when something happens. We've seen people picking up the pieces after a massive middle brain stroke where the documents weren't in place, and big issues that way.
Especially if you're in a second or third marriage too. So yeah. So we've touched on guardianship. A couple of rumors I'd like to dispel. Number one, you can't really do a whole lot before the kiddo turns 18. You might be able to get a letter from the doctor saying that they're incapacitated, which is a form letter. But the actual filing of the pleading cannot be done until the child turns 18. Second thing, it can be done at any time. So if you don't get it right when your child turns 18, it's not like you've missed the boat and you've missed the opportunity. The next thing is when you apply for a guardianship, there's the guardian of the person, which is called a partial guardianship, or a full guardianship, which is guardian of the person in estate. And I want you to think about guardianship like any other kind of legal proceeding. Your people are going to have to be served. There's going to be a court cost. It can be expensive. And the guardianship is meant to be during the lifetime of your child. So if something happens, you no longer want that guardianship, then you're going to have to explain to the court what has happened so that child no longer needs to be under guardianship. Years ago, I had a family who went and got their daughter, who I felt really was on the borderline of being incapacitated, under a guardianship to get out of a lease. They got out of the lease. They went to the court. They said, we're out of the lease now. We don't want the guardianship. The judge said, too bad. She's been determined to be incapacitated. You have it for life. And when you have it for life, you have to ask the court for certain things. Like if you want to move counties or states, you have to get court permission. It requires an annual review. So think about before you get the guardianship, and I know sometimes school districts will really push the families to do this. Think about doing the other powers of attorney that we've talked about. And then we've also had the supported decision-making document. Allison, I'm going to have you maybe make a few comments about that.
Yeah, on the supported decision-making agreement, this is something that kind of thrown around in the special needs circles a lot. In Texas, it's something that does exist. It doesn't exist in all states. And a lot of times it's recommended if you're going with a power of attorney, healthcare power of attorney, you got a student that's still in school, maybe they're going to stay in school till 21 or 22. But the point of it is so that way you can, be involved in ARD meetings and other things, maybe doctor's appointments. There's a lot of things. But there's some things, and Christina, you kind of talked about like an educational, kind of an educational power of attorney. So there's a lot of things that are out there. There's a lot of There's a lot of misnomers, even in the legal community, because if you talk to 10 different attorneys in Texas, 10 different attorneys will tell you 10 different things on, yes, you need, slam dunk. I mean, they're pro guardianship, and everybody that comes in their office needs guardianship. And then there's others that are, nobody needs guardianship, and kind of somewhere in between. And, kind of the approach that we took, we talked to a lot of families, and they say that their kids have not arrived yet. We're hopeful and we're optimistic. Maybe they're high functioning. Maybe they have ADHD. Maybe they're just 18 and they're making bad decisions. Welcome to everybody else's world, right? But sometimes the thing is you can start by the least restrictive of having that power of attorney, healthcare power of attorney, maybe the supported decision-making agreement. See how it goes. If the wheels, I always say wheels on the bus, wheels off the bus. If the wheels are off the bus, you do this, you go the least restrictive option, and it is not working, then you can, look at, the other options, partial guardianship or full guardianship. But an attorney like Christina is going to sit down with you. The thing is what I want to share with everybody is you don't have to know what the right answer is. It is okay. Just know your kid. Know your kid, because, and an attorney is going to sit down with you and do a lot of listening to, what the capacity is, what the deal is, and they're going to help walk you through what those options are and what might be the most appropriate. And then you can kind of move forward with that. Because I know a lot of people feel stress about that because they don't necessarily know the direction. But and if you sit down with someone and they're pushing one way or another and not kind of giving you laying those options out for you as they may be, then maybe that's not the right fit. Maybe that relationship is not the right fit for you, and it's okay to get up and walk away and get a second opinion. So I think it is a careful decision. We have heard of, unfortunately in the state of Texas, they refer to people as wards, like wards of the state or something. We have seen where wards have gotten, their rights restored and things like that. But like you said, I mean, it's anytime that it's up to a judge, you're at the mercy of that judge. Are they having a good day? Are they a bad day? Are they against guardianship, for guardianship, whatever it is that they feel? And there's a lot to chance with that. So I think it's important to try the first things. And if everything else doesn't work, then you can kind of, go the next step for sure.
And I think one last little thing, if you'll go back, is I told you wrong. I did put the little bullet point about the educational power of attorney. So everyone on the call, Allison and I have this educational power of attorney. It's not based in statute or anything, but I would say let Allison and I maybe work on this power of attorney a little bit together, and then if we're comfortable, we might release it to the public. Let's say that. We will promise nothing, but we'll work on it. Okay.
And there's some talk. I mean, in just being like transparent here, there is some talk and some feelings of like, what good is a supported decision-making agreement anyway? Like, don't I already do that as a parent? Don't I already listen and provide advice and guidance to my kid, whether they have special needs or not? So I think the biggest thing and the biggest, push on these is that, is when they turn 18 and whether or not you can be in an ARD meeting with your student. And the truth is every district is different. And honestly, even every school is different. We've seen some schools be very inclusive. They want the parents involved. Clearly, the parents need to be involved. The kid has an intellectual disability. And then we've seen some districts and some schools give a lot of pushback. So we're just kind of thinking about those things that might be like just one more, and like, for instance, the educational power of attorney, that might be something that you can take into those ARD meetings, even if you have no plans for guardianship or partial guardianship. So that's kind of the thought. But we'll be back with you guys on that for sure.
Updating beneficiary designations. I told y'all, I love beneficiary designations. So here's how I do it for my clients, and I do it for myself. I have an Excel spreadsheet because it makes me happy. I have one column of assets. I have another column that says which document controls this asset during my lifetime. Is it my power of attorney or a trust? And then I have another column and it says, where does this asset go when I die? And then you can check that yourself. You don't need a lawyer. Again, if your child receives an asset outright, we may have to put it into a first party or OOPS trust. And then the other thing is, once you send in that beneficiary designation, get confirmation back from the financial institution that they've received that documents, they don't have any questions. So then just to add a little bit more peace of mind and finality to make sure your plans are put in place. So
and I just want to mention here, it's real important. And the things that you forgot, the 401ks, the 403bs, the old pensions, your current employer, it's not just your life insurance. And again, you know, your beneficiary designations does trump everything, because I've heard people say, well, it's all in my will. It's all spelled out in my will. And it doesn't matter what's spelled out in your will. It's what is listed as the beneficiary. But the good news is you can look at this for free and you can update your beneficiaries for free. It doesn't cost you anything. All of the companies, carriers, they all have forms that you can submit. But I do think it is important that you do get those confirmations as well, because we've actually seen where it was submitted and received and customer service was busy and somehow they didn't process it and things like that. But one last thing I want to mention here too, it's not just our special needs kids. What a lot of people do is they leave their spouse's beneficiary, primary beneficiary, and then they say, okay, that's easy. If I die and my spouse is already dead and gone, then my assets are going to be divided equally amongst my children. And you want to think carefully about that, naming minor children, whether they have a disability or not, as a beneficiary, because basically what happens when you do this, if you make this mistake, and if you have, it's okay, you can fix it. 90% of people do this, okay? So you're not alone. But when you leave your money to a minor child, it sits in trust until the child turns 18, and guess what? Then the child gets all this large sum of money, and it's a bad idea. I know your kids are brilliant, mine are too, but most kids at 18 can't handle large sums of money. So there are smarter ways to go about doing that. So just if you're making notes of kind of what should be on your list, that's definitely it.
Allison's right. And the other thing too is to get that money into trust, you're going to have to go to court, which means 2 lawyers are going to have to stand in the same room together at the same time, which means you're going to spend a lot of money, or your state will spend a lot of money that should have gone to your child.
We did have a question. Someone earlier said special needs trust, is that the same as a first party and third party supplemental needs trust? So a first party and a third party, they're 2 different special needs trusts. A first party is their money. It's their money. Maybe it came from earnings. Maybe it came from a lawsuit or a settlement or things like that. Oh, sorry. I don't know what just happened here. Let me go back. lost our slides. So we'll get back there. But in the supplemental needs trust, basically, we are going back to the third party trust that doesn't have the Medicaid payback. Is that correct?
Correct. Right. So it first means it's the kid's money. Third means it's your money or someone else's money.
Okay. So and then just for confusion, the first party is sometimes called a self-settled trust, and the third party is sometimes called a supplemental needs trust, but they're basically one and the same that way. I think we missed a slide here. So the estate planning decisions, and I know that we're about out of time, so talk to us about the estate planning decisions.
So just quickly, number one, we're thinking about who's going to be the trustee. That's that time, talent, trustworthiness. Thinking about a sibling as a trustee, maybe that may be a good thing or maybe not. How to fund the estate, what's fair. So maybe the child on Medicaid gets more, maybe the child on Medicaid gets less. I go through every asset that the client has, and we figure out which asset's appropriate to go to the trust. Letter of intent. Also, you guys have a great video on the letter of intent. My firm and I, we've watched it. Basically, it's just a letter of instruction to the people who are going to carry on after you. You can do medical direction and instructions to the trustee. If you appoint people, let them know that they're appointed. You don't want any surprises. I don't know if you've gotten this or not, but beneficiary designations are important. And updating your documents. We call it the D's, the death, the divorce. Check those documents once a year. Make sure that their people are still willing and able to serve. And if you move to another state, you'll probably have to get brand new documents. Sorry about that, but at least have another lawyer check them out. So I think that's it.
Yeah, absolutely. And you know, those new documents and kind of updates, even with the guardianship of changing counties, that's a thing as well. So one thing that I just want to say, I know that when we have, you know, as many people as we have had on the webinar today, that there's a lot of questions. You have a lot of personalized questions as to your unique situation. Certainly don't want to put all that in the chat box. So I certainly invite you to reach out to Christina's office. If you've got documents that need to be reviewed, you've got old documents, they can certainly help you with that. If you need to have those conversations about guardianship and what you need to do there, certainly help you with that as well. And reach out to us. We can certainly help you with those future care cost calculations, the Social Security analysis, and dollars and cents, money in the right buckets. So it's certainly been our pleasure being with you today. Again, today's webinar has been recorded. You are going to get a copy of today's slides. This webinar is also going to live on our YouTube channel. Put that YouTube channel in the chat box. That'll be in the email as well. All of our past webinars live out there, and they are all related to special needs planning, college for special needs, SSI and Medicaid. It just goes on, the different topics. And quite honestly, all of these, there's so much to it that they do have their own webinar. And we've talked on a lot of different things today, but we have, you know, webinars on each of those topics if you need to go a little bit deeper. Thank you, Christina and Mandy, for being with us today. And as always, you do such a great job. So thank you.
Thanks.
Take care, everyone.
And I'm going to plug that letter of intent webinar too.
Yeah, we actually do have a letter of intent template as well. You can create your own, but we actually do have a template on that. So if you're wondering how to get started on that, check that webinar out. So thanks, everyone. Have a great afternoon. Bye now.